Hi, welcome to the webinar today that I'm hosting. My name is Babak Shamsi. I'm one of the attorneys here at Beresford Booth, PLLC. I'm doing a webinar regarding the state of Washington housing and housing legislation that was recently passed in 2023, and it's kind of an ongoing affair. I'm going to be focusing on just a couple of House bills in particular that have gained a lot of traction and garnered a lot of interest. And I'm going to go through just some of the basic overall provisions of those House bills that have been passed, talk about their applicability, and sort of go through some of the implications of them and considerations of the same. I'm not going to be going into the particulars of how this may impact particular communities, because these House bills are widespread state laws that are being enacted throughout Washington state. And they may have differing impacts on different communities based on population size and area and particular locations. And in addition to that, the adoption rate of these plans, if you will, these laws, I should say, will vary depending on the date of each city or municipality's comprehensive plan. So I'll start with the sort of outline of the two major statutes. So there's HB 1337 and HB 1110. HB 1337 requires adoption or amendment of municipal zoning regulations to allow at least two ADUs on all lots in an urban growth area with single family homes. And so essentially urban growth areas would be any kind of number of areas designated for urban growth, which exists outside of rural areas. And then HB 1110 requires cities to allow the building of duplexes, fourplexes, and or sixplexes, depending on population and other considerations. The statutes have been adopted. However, the actual date in which they will become effective depends on each municipality and city. So they must be adopted by the municipalities and cities so that they become effective in their land use regulations within 6 months after the respective municipalities or cities' next periodic comprehensive plan update. And that differs from city to city across the state. A lot of them are towards the end of 2024, however, and so we'll be seeing the adoption come into effect sometime in mid 2025 in most areas of Washington state, though not all. They are not all on the same exact timeline. But that is the general requirement, that even though the statutes have passed and are technically in effect, there is a sort of buffer time frame in which each city can formally adopt them into their process so that they are compliant. Edmonds in particular, which is where I am at currently, is meant to finalize its update by the end of the year, and so within 6 months after the end of 2024, it should all be adopted. The plan is called Everyone's Edmonds, and there are actually ongoing meetings that are coming up over the next couple of months discussing the plan and sort of finalizing the plan as we go towards the end of the year. And so that information can generally be found online if one were so interested in finding out sort of the ins and outs of what's going on in Edmonds. So I'm going to talk about each of these statutes separately, and I'm going to start with HB 1337. So HB 1337 requires the adoption or amendment of municipal zoning regulations to allow for at least two ADUs on all lots located in all zoning districts, within an urban growth area that allows for single-family homes. HB 1337 supersedes and preempts all municipal zoning regulations that fail to abide by its terms. And so this is very important because this is comprehensive. It essentially will supersede any inconsistencies in local ordinances and is effectively a top-down statute that requires the entirety of the state to comply accordingly. Homeowners can construct ADUs from the ground up. They can do it from existing structures such as attached garages, even if they violate current code requirements for setback or lot coverage. Again, it's a pretty expansive law with a lot of power. It also has a lot of prohibitions on what municipalities can do, but also allows and reserves some entitlements as well. I'll note that the statute doesn't actually say this, but it appears that HB 1337 does not supersede pre-existing CCNRs or CCNRs in general for homeowners associations that have prohibitive provisions. So while the statute is requiring the cities and municipalities to comply, it's not necessarily saying that homeowners associations have to comply with the statute. Indeed, it appears they can still prohibit them. Now, again, the statute is silent, so it may be that down the road an HOA tries to prohibit this, and there may be some dispute about that has to be resolved. But from my general sense, and I've spoken with a few other attorneys as well to get their general sense on this, the consensus, at least tentatively, appears to be that it can't prohibit that. So some of the prohibitions that HB 1337 has regarding cities and municipalities, it does stop them from requiring the homeowner to reside in or occupy any housing unit on the same lot. So all of the units can be rented. Assessing impact fees on the construction of ADUs greater than 50% of the impact fees imposed on the principal unit. And so, again, that essentially kind of caps the amount of fees that are assessed for purposes of the impact that the ADU has on utilities and that kind of thing. It prohibits municipalities from establishing height limits less than 24 feet unless the height limitation upon the principal unit is less than 24 feet. So it kind of creates a baseline there in which the height limitation on the ADU will be limited to the same as the principal unit. So again, just kind of creates a level area where the ADU can't be restricted more heavily than the principal unit, unless, of course, it gets in that 24 feet. Imposing setback requirements, yard coverage limits, tree retention mandates, restrictions on entry door locations, aesthetic requirements, or requirements for design review for ADUs that are more restrictive than those for principal units. So again, having the baseline be what is restrictive on the principal unit governing the ADUs. It can't be more restrictive on the ADUs. It also doesn't allow cities to prohibit the sale or other conveyance of a condo unit independently for the ADU independently of a principal unit solely on the grounds that it was originally built as an ADU. It doesn't allow cities to require public street improvements as a condition for permitting ADUs or require certain parking restrictions, amongst a few other limitations. So it's pretty broad in terms of the powers it takes away from the cities and municipalities to govern this. And, the import of this, of course, and the reasoning behind it is fundamentally both these statutes have to do with housing density. The Washington State Legislature is trying to address what many consider to be a housing crisis in Washington State, and opinions will vary on the severity or existence of a housing crisis here. But nonetheless, there have been talks about the housing crisis and the unavailability of housing throughout the state. And Washington Legislature has been adopting statutes in order to combat that in ways that they perceive to be a beneficial way of handling that. Of course, the jury is out, and there are a lot of different perspectives on these statutes, and I'm not weighing into that today. But nonetheless, I bring it up as sort of explaining the motivator behind these statutes, and also explains why they're structured the way they are. It's really trying to allow the building of ADUs to be as easy as possible, while also giving owners more flexibility in what they do with the ADUs. However, there are some reservations here in that cities and municipalities can still restrict the use of ADUs to prevent short-term rentals if that's what they want. So again, this is targeted towards housing, providing housing, not necessarily towards profiting off of extra Airbnbs. Now, of course, cities don't have to prohibit that, but the legislature is saying they can, and that is because, again, it gets back to the overarching purpose that the legislature is envisioning behind these, which is to provide more housing to people. It also entitles municipalities to apply environmental permitting requirements that would be otherwise applicable to the principal unit. and also prohibit ADU construction not connected to or served by public sewers, amongst a few others. So that's the general sort of outline of the HB 1337. And again, Edmonds has already started working on his comprehensive plan update in particular. And so again, we're going to look at sometime in 2025, 6 months after the end of the year, where this is going to be adopted. I believe Seattle's on a similar timeline last time I checked. And so I'm expecting that, again, most cities and towns are going to start to see this happening towards the middle of next year. Then there's HB 1110, which requires cities to allow the building of duplexes, fourplexes, and or sixplexes, depending on population and other considerations. And one of the challenges, actually, when they initially adopted this law was that units that were 3 units or higher actually had to follow the commercial building code. And so an interesting challenge was that whether a developer was developing a 3-unit, a 4-unit, or a 6-unit, or a 200-unit housing project, they followed the commercial code, which is generally more restrictive and more complex than the residential building code. And so that became a deterrent that the legislature, I think, did not initially anticipate. And so to supplement this statute, HB 1110, they passed HB 2071, which put projects of up to 6 residential units under the less restrictive residential code. So again, now duplexes, triplexes, fourplexes, sixplexes are all under the residential code, rather than putting anything above 2 units under the commercial code, which makes sense and frees up developers and construction companies to start to build housing where they don't have to worry about the fourplex they're trying to build meeting the same requirements that the 200-unit apartment complex they want to build needs to meet, like the same code requirements. And the legislature, I believe, thought that this gap that they're filling now with HB 2071, if they hadn't filled the gap, it would have had a bit of a chilling effect on developers' ability to build housing, or really not even their ability so much as their desire to do so, whether it would be profitable. Because again, these statutes are angled towards increasing housing availability, but the flip side of that, of course, is that developers are going to want to develop it, and owners are going to want to build the ADUs. And again, while the ADUs may be more owner-centric in terms of owners will build an ADU on their lot, a lot of the target audience, if you will, for HB 1110 are developers, because most duplexes, fourplexes, sixplexes are not being built. Most of them are not being built by mom and pop, their shops, or by individual owners who are kind of redeveloping their own land. For the most part, it is construction companies and developers who are going in, buying vacant land, or tearing down housing to build a housing with more density. So again, like HB 1337, HB 1110 supersedes and preempts all municipal and city housing zoning regulations that don't abide by its terms. It's on the same timeline as HB 1337. So again, within 6 months of the next comprehensive plan, which for Edmonds is, again, probably around mid-2025. I expect the same for Seattle. And just like HB 1337, we think that HB 1110 does not supersede CC&Rs that have inconsistent prohibitive provisions. Again, the statute is silent. I think it would have been good if it had been expressly stated one way or another, but nonetheless, it appears that in the absence of an express prohibition, CC&Rs of community associations, we think, have reserved that right. So what are the parameters of H1110? I'm sorry, 1110, because the final version of the law, it really depends on the population size in certain locales on what exactly has to be adopted. And so it's broken down into really 4 parts, if you will. So 1, cities with populations of 75,000 people or more have to permit construction of 4 units in all residential areas, and must permit the construction of 6 units in lots located within a quarter mile of a transit stop, or where 2 of the homes are considered affordable housing. So again, this is the larger population. So Seattle, Spokane, Tacoma, some others as well, of course. There's going to be a wide increase of construction of fourplexes as well as sixplexes in those areas in order to achieve housing density. And again, this is not a permissive thing. This is something that the cities have to allow, and is governed again from statewide. It's basically for any of those populations. So again, I think it will spur a flurry of building of fourplexes, especially now that they have added the HB 2071 to deal with the building code gap. I think we'll see a big opportunity for developers to build houses in larger, urban areas to achieve more density. I think there will be a big flurry of construction in order to do that. And I anticipate that will start to really hit, towards the tail end of 2025 and all that. So there is an opportunity for both developers and owners to kind of get on this, and investors to, kind of forecast that a lot of older homes may be redeveloped, vacant land. If you can find vacant land in places like Seattle, but certainly older homes may be redeveloped accordingly, and this is something that's coming down the pipeline, very much intentional on the part of the legislature. The second group are cities with populations greater than 25,000 but less than 75,000, where essentially they replace it with duplexes and fourplexes accordingly. So again, they have to permit construction of duplexes in all residential areas, and must permit construction of fourplexes in lots within a quarter mile of a transit stop, or where one of the homes is considered affordable housing. So again, instead of allowing fourplexes throughout the city, which is what it would require for cities of a population of 75,000 or higher, for these cities between 25 to 75,000. It's duplexes in all areas and fourplexes in those areas that are near transit stop or where one home is affordable housing. And then the third category is cities with populations under 25,000 people located within a contiguous urban growth area. So again, this isn't really for rural areas. So that's also key. It needs to be in an urban area, with the largest city in the county with a population of more than 275,000. So that's another parameter on that. So if there isn't a city in the county with a population of more than 275,000, then this doesn't apply. It must permit the development of at least 2 units per lot on all lots zoned for residential 3 use, unless zoning already permits higher density. Like if there's a zoning already permits something higher than that, then just it doesn't supersede it anymore. So it's kind of establishing a floor. And then so cities do have an alternative to these requirements, which is if they can allow the allowances above on at least 75% of the residential lots. So instead of doing it throughout the entirety of the city, if they can do it on 75% of the residential lots, then they can reach the goals in that fashion. But there are a lot of restrictions about what can be included, what can be excluded within that area. Limitations might include the fact that 25%, the 25% that's excluded, has to include all the environmentally critical areas, and can't include areas that have historic exclusionary covenants. And then there's a bunch of other rules that I'm not going to get into on this presentation, but effectively there are alternatives to this. And so it will be interesting to see how cities and municipalities intend to comply with both of these statutes. But it does forecast quite a bit of a sea change, I think, in construction that's going to be coming in the next few years. Because again, there's at least a discussion that's out there, and it's a pretty heated discussion about the availability of housing in Washington State, particularly in larger cities, and also how best to tackle that and from what perspectives. Certainly, I have talked with several developers who have indicated to me just personally that they find some of the restrictions too restrictive and kind of dampening their ability to build, and perhaps some of the legislature's intent here with the way they've crafted this legislation is to alleviate some of that. I think that some of this will just be ironed out as the process moves forward. I anticipate that as this gets going, there's going to be kinks that need to be ironed out and potentially challenges that are going to have to be addressed. But nonetheless, these two statutes, could create a large amount of new housing, a large uptick in ADUs throughout the cities, a large uptick in duplex, fourplex, sixplex unit residences, and could really, increase the amount of available housing. Whether that is something that is, good for the market, bad for the market is I think, something that could be discussed between people, but it is coming. Absent a challenge to the validity of these statutes, it is happening, and cities are already planning for it. Like I said, Edmonds is having meetings about this in the next few months. I expect Seattle is also going down that route, as are other cities. And it is required by the Washington State Legislature. And so it is a matter of just how do the cities adopt it, and in what fashion do they find themselves able to comply with it best. And so if you are a homeowner or developer or anyone in particular who just has an interest in these issues and ever wants to reach out to me with questions about this, again, there's a lot of details involved with not only the statutes but how they're being adopted. And right now it's a bit of a question mark because they haven't really gone to effect. I mean, they are technically in effect from a legal standpoint, but from a practical standpoint, they just haven't been adopted into the plans that the cities have. And so there's a bit of a waiting game to see how this all plays out. But if you have questions, my information is there on the screen. Feel free to give me a call or send me an email. I'd be happy to talk to you. I hope you found this presentation informative today. I know it's a bit high level, but nonetheless, there's a lot of details to it that'll get fleshed out in the coming year or so, and stay tuned for more, and hopefully we'll find out kind of how this is all going to play out. Again, thanks for attending today's webinar. I really appreciate it. Again, feel free to reach out to me with any questions, and I wish you a great rest of your day. Thank you.